behalf of the European Foundation of Human Rights, I would like to thank you for coming. It is very nice to see you all here. We also want to thank the Embassy of the Republic of Poland in Vilnius, the patron of this project. Today we are going to take part in a training called The Language Rights of Linguistic Minorities, International Standards and Their Significance. This training will look closely at the international human rights standards, which form the basis of the recently published United Nations Practical Guide on Language Rights and its significance. This guide will be used during this training, so if you haven't downloaded it yet, you may still have some copies left. As you probably know, this training will be conducted by Dr. Fernand de Verennes. He's a professor at the Faculty of Law of the University of Pretoria in South Africa, and a visiting professor at the National University of Ireland, Galway. He also has a mandate of the United Nations Special Rapporteur on minorities and focuses particularly on the issues relating to languages. It is important to mention that certificates for this training will be handed out at the end of this event, and we kindly ask you to fill out the evaluation forms that you have received earlier. All information and material of this training will be posted on our foundation website. So before we begin the training, I would like to take this opportunity and present the organization that made this event happen. And if you try, I'll just turn on my slides. So, the European Foundation of Human Rights is a non-governmental organization actively operating in Lithuania since 2010. It was established in response to a striking increase in abuses of human and national minority rights in Lithuania, observed after the country joined the European Union. The aim of our activities is to raise public awareness on the human rights, tolerance, equality, racism, discrimination, and intercultural dialogue. Although the scope of the Foundation's activities is very broad, the four main areas can be distinguished. Since we work on legal grounds, the mission of our activities is to offer free legal advice to anyone who became a victim of discrimination and human rights abuses in the public or private sphere. Our legal aid can provide consultations, preparation of legal documents, assisting in the court proceedings, and in other institutions. Human rights education is another very important topic, so the Foundation also organizes free human rights workshops and lectures by professors, scholars, and experienced lawyers. They are intended for school pupils, students, lawyers, and other interested persons. Our NGO actively cooperates with high schools to organize lectures on problems such as discrimination, human rights. Also, Foundation prepares and distributes leaflets and other publications about discrimination, human minority rights, hate speech, hate crime, and original name spelling. Foundation is also promoting the non-hate speech movement, thus actively monitors media and cyberspace in order to promote the tolerant and the peaceful society. According to the criminal code, each comment or statement publicized on the internet that openly incites hatred and discrimination against a particular group of people is forbidden and is subject to penalty. So, Foundation is scanning the internet, media, and public life, looking for manifestations of hate speech and taking legal steps afterwards. Moreover, the Foundation team pays attention to job advertisements and discrimination against a particular groups of people, and cases where the job profile does not require any special abilities from candidates. This kind of selection criteria, like age, gender, ethnic, or racial origin, is illegal. So, Foundation monitors and acts against those abuses by applying petitions to the Lithuanian Equal Opportunities Ombudsperson Office. So there are many different events and projects within the foundation activities. As I mentioned before, we organize free of charge trainings, workshops, conferences, and lectures on human rights. We organize educational visits to regions far from the capital of Lithuania. We also implement educational projects and disseminate information on legal aid center through the leaflets in Polish, Lithuanian, Russian, and English language. It is important to note that foundation regularly draws up reports to international organizations dealing with the protection of human rights, for example, Committee on the Elimination of Racial Discrimination. Examples can be seen in this slide. And the newest report was prepared in 2018. It is about the Framework Convention for the Protection of National Minorities in Lithuania. We try to be seen and recognized in social and public media. So as for this moment, we have over 12,000 likes on our Facebook pages in Lithuania and Polish. And we have more than 3,000 articles related to the situation on human rights in Lithuania translated into English and published on media.efhr.eu. And we have about 2,000 monthly visitors to our website. And European Foundation of Human Rights is a socially involved organization, so it cooperates with national and international organizations and universities. It participates at international seminars all over Europe and charity activities. We also have over 100 volunteers each year who help us to carry out our daily tasks and projects like this. And actually, that's it. And that concludes my talk for today. And thank you very much for your attention. And now please join me in welcoming Professor Dr. Fernand de Verennes.
Thank you very much. Merci beaucoup. Bonjour tout le monde. Were you told that my presentation would be in French? It is my language. First, please allow me to express my gratitude to the European Foundation of Human Rights for the pleasure and the opportunity to be involved in one of their training activities. EFHR is one, in my opinion, is one of the most prominent, and I would add effective, non-governmental human rights organizations in the Baltic states, including in areas such as the fight against hate speech, especially in social media, the human rights of minorities, and more generally, the human rights and the importance of the respect and acceptance of diversity in society. It's also nice being back here in Lithuania. And I say back here because I actually taught at a university in this country. I was in Kaunas. I was teaching at Vytautas Magnus University, which has, as you know, the best faculty of law in the country. Yes. By the way, I think I recognize some of you from perhaps the last time I was here. A few faces seem familiar. So before I begin on the actual theme for this training session, I thought I'd take the opportunity to give a few words, to say a few things about the mandate that I have. I am, as was indicated, the United Nations Special Rapporteur on minority issues. So I'd like to talk about that a little bit, to give you a sense of what I am doing with the United Nations before I continue on with the substance dealing with the language rights of linguistic minorities. I should also add, because I think it's important, I'm also a visiting professor at the University of Hong Kong, where I'll be teaching, in fact, next year for 3 months, in addition to the other positions that I have, you can see there. I am a little bit busy. Once again, it's quite a pleasure being back. And tonight I'm going to eat zeppelini. I really, really like zeppelini. I am an independent expert, elected last year by the member states of the United Nations Human Rights Council for a mandate of 3 years, renewable only once. So the mandate I have received includes the following: to promote the implementation of the UN Declaration on the Rights of Persons Belonging to Minorities, to identify best practices and possibilities for technical cooperation. And that means cooperation between the United Nations human rights mechanism and different governments of different states. As part of my mandate, I also have the obligation to raise awareness and work for the full and effective realization of the rights of persons belonging to minorities. And this activity is part of my mandate, in a sense, to raise awareness on the issue of the rights of minorities, including, well, in this case, linguistic minorities. I am also to engage in dialogue with governments, with states, national bodies, international and regional organizations and civil society. One of the activities related to that is what is referred to here behind me as the Forum on Minority Issues, which is held once a year at the United Nations in Geneva. And also, as part of my mandate, I actually have an obligation to incorporate, to apply a gender perspective in relation to minority issues. How do I do that? There's a number of ways, and I'm not going to go through the detail of all of them, but some of them involves what is called a special procedure. I am actually considered as a special procedure of the United Nations. When there are situations where the human rights of minorities may not be respected, individuals, organizations, even governments can send an allegation of a violation of the rights of minorities to my mandate, to my office in Geneva. And I actually, as an independent expert, have the authority to investigate, or rather to inquire with the government to try to clarify if there is a possible violation of those rights, or if there is not, and make a report to the Human Rights Council of the United Nations, but also perhaps in some cases, if it is appropriate, to make recommendations as to whether there has been a violation and what should be done to correct that. And my mandate also includes country visits or country missions. And that means spending a fair amount of time in a country at the invitation of a government, or at the approval of the government, to look, generally speaking, at what is the human rights situation of minorities in that country, all minorities. And usually this is for at least a period of 2 weeks, at the end of which I prepare a rather substantial report, significant report, indicating, well, the good and the not so good. Because in every country, there is no country in the world which is perfect in relation to human rights. Some countries do a little bit better than others. Canada, I'm Canadian, by the way, Canadian and Australian. Canada is pretty good, I think. But there are a number of areas where, yes, there can be improvements. And it's part of my mandate when I conduct country missions to commend, to actually acknowledge, to indicate that the government is doing well in some areas. But there are areas which I identify where more has to be done to improve the situation. And this, hopefully, this kind of mission, which is part of my mandate, hopefully can lead to not only a report where all of this is pointed out, but also a continuing dialogue over the years with the government in order to try to make sure that these improvements are put into place. My first country mission, was in Slovenia earlier this year. My second country mission was to Botswana in Africa, because I think it's clear my mandate is in relation to religious, linguistic, and ethnic minorities around the world. And believe me, it keeps me busy. And I also conduct annual reports to the Human Rights Council and the United Nations General Assembly once a year. In fact, before coming here, I was in Sarajevo for a few days, but immediately before that, I actually presented my annual report to the General Assembly of the United Nations in New York. And I have to return to New York in a few days and then go to Canada and then go to Africa once again. So it's a great mandate, but it is rather demanding. Now, before I go into the substance, I just wanted to mention very quickly that there are a number of areas that my mandate is focused on, where I have a number of priority areas. These include statelessness and minorities, the issue of education and the rights of minorities, particularly in relation to language, hate speech and intolerance against minorities, and the issue of, well, conflict prevention and minorities. Why the emphasis on minorities with all these issues? All these issues are particularly important in relation to minorities. Very quickly, just one of them, or maybe two: statelessness, individuals who have no citizenship. There are, according to the UNHCR, the United Nations High Commission on Refugees, there are at least 10 million stateless people in the world. And according to the UNHCR, more than 3/4 of them are from different minorities. You have all heard, I think, of the Rohingya from Myanmar, Burma. 1 million of them are stateless. Many of them, about 3/4 are actually find themselves right now in Bangladesh. They've fled Myanmar because of violence and other situations there, or violations of their rights. That's one ethnic group, the Rohingya, and they represent almost 10% of the world's stateless people. They are amongst the most vulnerable, the most marginalized people in the world. Statelessness is a situation where individuals can be very vulnerable, and it is a minority issue. More than 3/4 of the stateless people in the world are from minorities. This is true also in Europe. Most stateless people here in Europe, the vast majority of stateless people in Europe, belong to two minority groups. Only two. The Roma and the Russians in the Baltic region. Some Russians that are stateless. In addition to those priorities of my mandate, once again, it is a requirement, in fact, that I incorporate gender issues in my work. I do that consistently. And finally, there will be one of the priority work is to try to clarify the concept of what is a minority. This is always an issue in Europe. We have some questions about that, some uncertainties, although not exactly the same ones as you have here in Europe. In Europe, you always talk about national minorities. In the case of the United Nations system, it's different. The United Nations system is actually more focused on ethnic, religious, or linguistic minorities. You will very seldom hear me talk about national minorities as part of my mandate. My mandate is actually more linguistic, religious, ethnic minorities. And if you have questions about that later, we can perhaps try to clarify. There are also two, I should mention in terms of my mandate, there are two minority groups specifically that are of interest and focus under my mandate. One of them are the Roma, of course, here in Europe, but not only in Europe. There are Roma communities in other parts of the world. And also, finally, another group that I'm focused on, another minority, are members of the deaf community who use sign language. Those who are deaf, who do not hear, and use sign language are using a language. If they use a language, and they're less than half the population of the country, they are members of a linguistic minority. And this is something that is not always well understood, but is one of the priority themes of my mandate also. So, ladies and gentlemen, that was a few words before the beginning. It's going to be a long day. So I would suggest to make it a little bit more interesting, we might try to have an interactive dialogue and exchange. In other words, instead of listening to me speaking for the next 4 hours, which would be horrible, I can relate to that. As we go along, I would invite you to, if you have maybe things to share, you would like to ask questions or want a clarification, to not hesitate. Send a signal of some kind, and I think we might try to make this more interactive. Otherwise, just listening to me speak will not be very interesting for 4 hours. Okay, so any questions at this point? No? You can hear me well enough in the back? My accent is not too difficult to understand? No? Good, good. As I said, I am a Canadian Australian, French Canadian Australian. I come from the French-speaking minority in Canada, not Quebec, another part of Canada. And English is actually a foreign language for me. I learned English a few hours a week. All of my education, in other words, was in French. But when you're a minority, usually it's not too much of a problem to learn the majority language. Okay. Really, no questions? I need to drink some coffee. I was working on this since 3 in the morning. Good, okay. So we'll start with a brief look at the evolution of what we call today the minority rights especially. Because when we talk about the language rights of linguistic minorities, we're talking about minority rights. But to understand what that means and how that connects to human rights, which I will be making that connection as we go along, you need to know the history. Because the history really goes back to the beginning of the 20th century. And I know it sounds a long time, 100 years, but it explains a number of issues that you have, especially here in Europe. You know, this concept of a national minority is delicate, is complicated in Europe. But there's history behind that. There's history in the way we deal and talk about minority rights also in international law. So in order to understand where we are, I think it's important to understand where we came from, and especially therefore where these minority rights came from and why they developed the way they did. So this may be a bit long, but I think it'll make you perhaps appreciate more why there are these challenges and issues in relation to minority rights and before the language rights of minorities. And here is perhaps about 100 years ago, if we can go that far, is the first time that there is a connection in terms of the first emergence of minority and human rights in international law and politics at the beginning of the 20th century. You have to understand, when we talk about international law, we are talking about a restriction on the sovereignty of the state. And at the beginning of the 20th century, that concept is difficult to accept, especially when it comes to how a government can treat its own citizens. Because when we talk about human rights, that is the very point of human rights that are part of international law. That the way a government treats its citizens is restricted by these norms that we call human rights. At the beginning of the 20th century, that's very difficult to accept. Now remember, at the beginning of the 20th century, many parts of the world are colonial colonies, where the practice is for the colonial power, France, England, and a few others. But individuals who live in their colonies really have no power. In Africa, the Black Africans really had no say in the way colonial powers exercise their authority. And so at the beginning of the 20th century, it's interesting to see that there was, at the time of the creation of the League of Nations, those who study international relations or history will know that the League of Nations did not include human rights in the treaty that created the League of Nations. There were no human rights, basically, at the beginning of the 20th century in terms of international law, let's put it that way. However, there was one attempt to develop or to include at least one human right under the League of Nations treaty that would apply to all countries or all states that were members of the League of Nations. And this was a proposal by Japan. Japan actually made a proposal under the League that the League of Nations have a provision in its charter prohibiting racial discrimination. Now, that would have been the first time in international law that you would have had a binding rule that could be described as a human right. But this was rejected. And it was rejected because at the time it was felt, some governments felt, that this would limit the sovereignty of the state too much. It was a limit to the sovereignty of the state in the way it dealt with its citizens. Now, remember also the context. Racial discrimination at the beginning of the 20th century was widespread in countries like Australia. I am an Australian citizen, so I can say that. At the beginning of the 20th century, Australia was one of the most racist countries in the world. There's no doubt. There's no denial of that right now. At the beginning of the 20th century, countries like the United Kingdom, France, and a few other European ones were practicing racial discrimination on a daily basis. In the United States also, if you were black at the beginning of the 20th century, do you think you did not experience racial discrimination? Racial discrimination was widespread. So when Japan, and notice Japan is not a European country, when Japan at the beginning of the 20th century said, let's prohibit racial discrimination as part of international law, well, quite a few European and Australia and also the United States, those countries rejected the idea. And it's more complicated than that. But what happened subsequently is this. Instead of having a human right applying to every country or every member of the League of Nations, what was proposed instead was that there should be a series of bilateral treaties or special treaties and other documents, unilateral declarations that would be limited to the protection of minorities. In other words, there was a bit of a compromise that happened here. There was a recognition that the issue of minorities were important, by the way, and I present to you behind me the issue of the assassination or the event of the assassination of the Archduke Franz Ferdinand and his wife in Sarajevo, which I visited the site 2 days ago, in Sarajevo, where he was assassinated. It was recognized that the issue of rights for minorities needed to be addressed because, as you may know, the spark, and I say not the cause, but the spark of the First World War was this assassination. Now, there were many geopolitical factors involved, economic, military factors that contributed to the war, but the immediate spark that led to the spiral towards the First World War was this assassination planned by members of a minority group, actually. My minority group, which aimed at the separation from the empire. By the way, the minority group is a Serbian minority group that asserted that they were actually treated unfairly in the Austro-Hungarian Empire. Now, if we were to use a modern vocabulary to what they were claiming that they should separate because their rights were being denied. They were treated in an unfair way. We could even say their grievances could be connected to claims of discrimination in a number of areas, if we use the modern language and try to decode what happened. So, as a result, if you will, and despite the inability of establishing a clear right of self-determination at the time for minorities, because this was referred to, that maybe self-determination is a political concept, should grant to nations the right of self-determination. Wilson and Lenin were talking about that, which seems to suggest that certain minorities, certain contexts, have the right to secede. They have their own state. So instead of recognizing a right of self-determination for minorities, although at the same time being sensitive here to the fact that minority issues and claims that minorities are treated unfairly have to be addressed. The suggestion of Japan, in a way, was part of that. Let's prohibit racial discrimination. Many European countries, the United Kingdom, Australia, and the US, which, although not a member, presided over the League of Nations, by the way, they were not ready to accept that as a limit on the sovereignty of the state. But what they were willing to accept is that there should be a number of other treaties that would only apply to those countries who are too weak. By the way, that's I wouldn't say it's clever, but it explains a number of things which we should keep in mind. So, universal human rights at this point of time, no. Because universal human rights would have applied to all member states of the League of Nations. Powerful states, the colonial states, did not want that. They recognize that, well, we need to address the issue of rights somehow. So how do we do it? We do it by only forcing the countries that lost the First World War, that were defeated during the First World War, or some new countries or weaker countries, only them will have certain obligations. Ah, that's interesting. Those are what we call the minorities treaties, by the way. Remember that. Some of you, if you've studied minority rights issues, may know about this. The minorities treaties, the first treaties that recognize the rights for minorities in international law. However, and they apply to a limited number of countries as you have here. They applied on countries that were defeated, such as Austria, Hungary, Bulgaria, and Turkey. New countries that were that emerged from the remains of the Ottoman Empire, and such as and others that were altered or changed under the principle of self-determination. And there were also a few what we're called unilateral declarations that involve also Lithuania, as a matter of fact, at the time. Now, these were, as I said, all of those treaties and unilateral declarations are known as the minority treaties. We don't have universal human rights yet, but we have minority treaties or minority rights. Now, here I'm going to start saying a few things that are challenging and slightly unusual or unorthodox. These treaties are often described as recognizing collective rights, group rights. They're often presented, and I think most books that describe them briefly will say, well, they were special rights for only certain minorities. That's actually incorrect. I invite you to go read the original documents, and I'll talk about that a little bit more. But it's always a good approach to not believe what everyone writes about certain issues, or to believe what some people tell you. You don't have to believe everything I tell you, although it would be a good idea, I think, personally. But I would invite you to go look at one of these original treaties from after the First World War. I'll describe them, but once again, you should do that. They can be found on the internet today. So what I want to emphasize to you is that these instruments were adopted in part in recognition of the vulnerability of minorities. There's no doubt about that. They were also adopted instead of having universal human rights that would apply to all states. That's true also. But there's also another dimension, which is what people have not understood or appreciated. If you look at these treaties, you will see that most of the content of these treaties are actually what we would describe today as human rights. This is an important aspect, because when we talk about the language rights of minorities, it actually already appears in these documents from after the First World War, but they appear connected to human rights standards, universal human rights standards, as I'll be explaining later on. So there was no appetite during the Versailles peace agreements negotiations to include universal human rights that would apply to all members of the League of Nations, but there were the acceptance that certain rights should be included. When you look at these treaties, most of these so-called minority treaties, if you try to, you look at each section, each provision, what do you see? I've used here the treaty which was involving Poland. It was the first treaty that we would describe today as the Minorities Treaty. And it served as a model for others. They're not identical. In fact, many of these treaties contain a lot of other issues, such as borders, in fact, or the transport along rivers between different countries. But in relation to the, if you will, the human rights or the minority rights provision, what is interesting, what should be noted, is that the majority of the content actually does not deal with minorities. They deal with human rights for everyone. For example, only 10 out of 19 provisions, articles in this treaty, the one involving Poland, 10 out of 19, more than half, deal with human or minority rights. And about a bit more than half of those are mainly human rights provisions for everyone, not minorities, everyone. For example, Article 2 deals with the protection of life and liberty of all inhabitants without discrimination, freedom of religion or belief. It doesn't actually limit those rights to minorities. It's actually for all individuals who are in Poland. So that's actually a human rights provision, a general human rights provision that we have here in what is called a minority treaty, but this is actually for everyone. Articles 3 and 4 deal with the right to nationality of all inhabitants, all habitual residents, or those on the territory of Poland, although there is sometimes some reference to minorities. This is also important for a reason I'll mention later. But that provision actually says, after the First World War, individuals who normally live or habitually live in a country are citizens of that country. That's very different from what we have today, isn't it? But that's an interesting concept, which once again deals also with the modern problem of statelessness. Article 5 indicates that there is no hindrance to those who have elected or not to be nationals of Poland. So in other words, if you decide you do not want to be a citizen, you actually have that right under that treaty. And this is, once again, it's not limited to minorities. This deals with everyone possibly. And then it goes on to other provisions, including Article 7, which is a general prohibition of discrimination for anyone or everyone, and the free use of any language in private activities. Once again, these are the last one in particular, is not limited to minorities. This is a universal human rights provision, guaranteed that we would recognize as such today. Now, there are some that are more specifically connected to minorities. Articles 10 and 11 deal with the Jewish minorities specifically. Article 8 deals with the equal treatment of minorities, including their right to have their own institutions that reflect their religion or language, and a few other things, such as Article 9, the right to use, or the right to a proportionate use of minority languages in public school for linguistic minorities, and that's also a share of funding. Now, I wanted to bring this to your attention because it signals an error in the way most experts or academics or scholars talk about these minority rights treaties. To describe them as minority treaties is incorrect, because most of the provisions of these treaties actually apply to everyone. So really what we should be calling them are human rights treaties, with special provisions, yes, for minorities, but most of the content of these treaties are actually universal human rights. Interesting. But for whatever reason, we have not recognized that most of these documents include, for example, the recognition of the right to everyone to equality without discrimination, the right of everyone to protection of life, liberty, and the exercise of religion without discrimination, and so forth. One of the things that perhaps should be pointed out before we continue is that these treaties are often described as being failures. I think some of you who have either studied this area will have heard that. Sometimes it's actually suggested that these treaties contributed to the eventual explosion of the Second World War, that the minorities treaties were instrumentalized by Adolf Hitler and the Nazis, claiming that the German minorities were mistreated, that these provisions were not protecting the German minorities sufficiently, so therefore Nazi Germany had to protect the minorities in the former Czechoslovakia, for example, and also I think perhaps Poland. This description, or the blame attributed to the minorities treaties, explains why, for example, after the Second World War, there was a refusal at the international level to recognize minorities as holding any kind of rights. The Universal Declaration of Human Rights, which was adopted, as you know, in 1948, or 47, I forget, 48, does not use the word minority once. The European Convention on Human Rights also avoids using the word minority. After the Second World War, the decision was made that, yes, we should recognize human rights, but only individual human rights. And we should not recognize minority rights because, well, these treaties were failures. They were instrumentalized, used by politicians, populist politicians, to create instability and conflict. But I want you to keep this in mind, that the content of that treaty actually is a human rights document. Most of those provisions are actually not minority provisions. They're actually human rights provisions. So it's interesting in the sense that, does it mean that we should blame human rights for the Second World War? I don't think so. But I'm just pointing out to you that there was, because of this development, evolution, after the Second World War, we really had a resistance from many governments to the whole concept of minorities because of the blame attributed to these documents for some of the way they were used by some countries, some governments. Are there any questions or comment and clarifications on that at this point?
When you tell about German rights in Poland, you have occasion Silesia region.
Yes.
Silesia.
And yes.
And now, in these days,
Mm-hmm.
in 21,
In
these days,
even now, you mean?
even now.
I was talking more
Not
historical.
after the Second Mondial War, but now.
Even now.
This time.
Yes.
Yes.
But no, in fact, I'm limiting my comments to how these treaties were used by politicians to claim that minorities were being mistreated.
Because I have many writers
Yes.
and portraits
Yes.
from Poland, I know Poland very rich, that live in this region, in Silesia, but they not talk many about German people rights in this region.
This region. Okay, thank you.
It's not talk many.
Okay, thank you very much for that. Yes.
I'd like to ask you your, let's say, comments, opinion, according to the first international treaty that was between Greece and Turkey in 1923 after the war, Lausanne. That was the first case when two country states simply agreed to exchange their minorities. And then you have something with this 1,500,000 Greeks from Anatolia, they were, transferred to Greece, and something like 200 to 400,000 Turks and Muslims from Greece transferred to Turkey.
Mm.
Now, I'll say that is basically what international law and community accepted as something what is, let's say, to become the normal, that if two countries agree, according to their bilateral agreements, to exchange their minorities, this is something what is, let's say, accepted by the rest of the international community.
I think in the time, if you put that in a historical context, that's true. Today, however, one would have to say that in relation to the Turkish minority in Greece or the Greek minority in Turkey, there are still a few people there, that whatever the bilateral agreement provided for, those two minorities have rights under international human rights law today. Because there may be issues involving the Turkish minority or the Greek minority in those countries that could still raise allegations of violations of human rights, even if this was allowed by the treaty in 1923. So just make sure, in 1923, remember, universal human rights do not exist. Essentially, governments can do with their populations whatever they want. Today, that's no longer the case. So even if the Treaty of 1923, is it, provided for limited rights, let's say, either for the Turkish minority or to the Greek minority, today, even though that 1923 treaty might permit that, you cannot use that 1923 to allow discrimination that is prohibited under for example, the Covenant on Civil and Political Rights. So I think that's how you have to look at it. From a historical point of view, yes, what was done in 1923 was legitimate, was permitted. However, today, the way each government treats its own population is limited by those norms of international law, international human rights law that are applicable in Greece and in Turkey. Yes.
But again, according to my, let's say, opinion, that was just political, let's say, wrapping how to legalize what was de facto did the other principle. I mean, of those two minorities by their governments.
Yeah.
That is simply legalization of every principle. Just how say nicely wrapped in some international agreements.
Oh yes, okay, yeah. Well, but once again, remember, I think we have to keep in mind the historical context. The historical context in that period was ethnic cleansing was permissible. In international law, you don't have any human rights in 1923. So therefore, today we would judge that situation as morally unacceptable, yes, but the rules of international law have changed in relation to the situation of the Rohingya that I mentioned today. In a sense, what has happened in Myanmar is described as ethnic cleansing by the UN Secretary General recently. And there are violations of international norms, clearly. But you cannot apply those norms to 1923, obviously. Ethnic cleansing was allowed. Countries could deal with their populations whichever way they wanted before the Second World War. In fact, that's one of the problems. One of the issues that permitted the government in Nazi Germany to adopt racial laws the way it did. Because before the Second World War, remember what I said, Japan proposed that racial discrimination be a norm of international law. And it was mainly Western countries, Western democracy that rejected that. So when Nazi Germany decided to adopt the Nuremberg laws against the Jewish minority, particularly, that was allowed. And I think that's important to look at this evolution. There were limited treaties for minorities that did contain mostly human rights provisions, but they only applied to a few countries. Very weak. Only applied to countries which were not victorious after the First World War. Imagine if the Japanese resolution had been approved and racial discrimination had become a norm in international law. It would have been more difficult for Germany to adopt racially discriminatory provisions, laws. They probably would still have done it, but it would have been more difficult. It would have resisted. And perhaps we would have dealt with the situation of the Holocaust differently also. As you know, that the Holocaust was in fact denied by Western governments for a long time. In a sense. The governments knew about this, that something was happening, but they didn't want to recognize it. So anyway, I'll go further, but thank you for your question. Did you want to add anything to that?
Well, I mean, you mentioned now this migrant case.
Yeah.
I mean, now the question is, we know what's going on there. We know what is going on in Israel for 70 years with those Palestinians. There are 44 United Nations resolutions against Israel. The Americans are using veto, and simply that's it. Now, my practical question is, what is called to be international community or United Nations for whom you are working? Now, how to solve such kind of problems? Or if, those who are the great powers, they have such kind of rights on their own protected territories, they are trying to do whatever they want.
I think you have to distinguish, and that's really almost like the end of this trend. I think you have to distinguish between the recognition of human rights as universal norms and the implementation of them, the mechanisms to actually try to implement these. We have developed a lot of norms in terms of human rights in international law. What is seriously lacking is their implementation. We do not have an international court of human rights. We have committees that are, as you probably know, persuasive but not determinative. They actually cannot enforce any kind of conclusions they have. So we will talk about that further later on. But the problem is not that we have universal norms dealing with human rights. The problem is that there is not the political will of governments, of many governments, to actually have strong enforcement mechanisms. And I think this is the next step. And I think one of the advantages of looking at this from a historical perspective is to show you that it's an evolution. We only developed international human rights treaties after the Second World War. In fact, the universal treaties, the international treaties, the Covenant on Civil and Political Rights, the Covenant on Economic, Social, and Cultural Rights, the main general human rights treaties, only came into force in the 1970s. Now, I want to emphasize this. Historically speaking, when we talk about the norms of human rights at the international level, they're actually quite recent. 1970s, 50 years ago. I think, yes, the essence of your question is it's not working. We have the rules, but it's not working. It's part of, and I would actually say you're right. But you have to look at where the problem is. And the problem is we haven't developed the norms with the necessary enforcement mechanism. That's the way I would present it. And I think that's the evolution that needs to continue to be done. So once again, think of this in terms of historical terms. After the First World War, there's a rejection of universal human rights. We only got the approval of most governments in the world to the norms in the 1970s. That's nothing from a historical point of view. Most governments politically are still not willing to accept strong enforcement mechanisms, including here in Europe, I would add. And that's a weakness, that's a problem, because that means you cannot intervene directly in situations, or exception, you cannot intervene directly in situations like Myanmar. But that's going to have to be the next step to how to make it stronger and more effective.
Okay, but still we are those countries according to be democratic.
Don't confuse democracy and respect for human rights.
I would say this is one of the basic pillars of the democracy, at least from the...
Not always. Remember what I said at the very beginning, again, and this is important to try to break down some misconceptions. Which governments, the example of Japan was a democracy, by the way.
I mean, Japan was,
still
is purely ethnically Japanese state.
Let me finish. Okay. Japan was a democracy. And those countries who actually rejected the Japanese approach were also democracies, especially Australia, especially the United Kingdom, and especially the United States, which was presiding over the League of Nations. They were essentially racist countries like that. And the point I want to make, which is important, is even though they were democracies, we would think of them as democracies, in reality, they were democracies which were quite, that society disrespected the rights of certain groups of their population. They would not accept the idea of human rights at that time for everyone. Democracy is a political system which is more amenable to certain rights, but it does not mean that democracy is synonymous with human rights, because human rights are limit on the sovereignty of the state. So I think it's important to distinguish the two. I would agree that human rights, that democracy are more sympathetic with certain human rights, but I would never support, or I would not be convinced by the argument that a democracy is equal to full respect of all human rights. That's not the way, that's not the reality.
anyway, I would say that human rights and minority rights as well are one of the two important, if not very important, pillars of what is called to be political democracy around the world.
Once again, but I think this is an important, interesting exchange. But once again, I mean, I could give example after example. In the case of Australia, Australia was, when it became independent as a democracy, a Western democracy, one of its first laws that it adopted was a law against immigration of Asian people. And actually, it was very clear in the debate in Parliament in Australia. The politicians were clear. We do not want yellow people to contaminate the white population of Australia. Okay. It was a democracy. But, shall we continue? By the way, and I'm not sure, when are we supposed to have a break? Okay, so let's continue a little bit with the, and thank you for that exchange. On the issue of language, there were in those minority treaties quite a few provisions on language. I will emphasize to you that they dealt with, for example, the free use of any language in private activities. Now, this is also connected. It was under that minorities treaty, but it was more connected to freedom of expression, in fact, because it was not limited to minority language, but any language could be freely used. And that comes up also today in other areas. In terms of, there were a few other provisions dealing with granting facilities to enable nationals of the country whose language was not an official language to use it in certain situations before courts, in application of the concept of proportionality. Nationals, once again, in those countries whose mother language was not the official language, should have adequate facilities, at least for education at the primary level in their own language. A couple of things here. They don't always use the term minority. They use the expression in these minority treaties, or treaty as they are now known. They use the expression that you can have an official language, but individuals whose language is not official, in certain situations have the right to use it. Because official language is not always the language of the majority, by the way, especially in other parts of the world. And here you have, I think, another indication that even though we've interpreted these treaties as minorities treaties, in fact, quite often, they are just general human rights, applicable to everyone, including in the area of language. The example of not having any restriction on the free use of any language in private activities. If we were to interpret look at that today in terms of universal human rights standards, that would clearly be connected to freedom of expression. Absolutely no doubt, as I'll be explaining now shortly. So one of the things, or one of the ways of looking at these treaties and provisions that either refer to minorities and the use of their language is to look at the jurisprudence of the Permanent Court of International Justice. The Permanent Court of International Justice, which was not permanent, only existed between the Second World Wars, did, however, interpret some of these treaty standards, norms, to try to clarify, if you will, the nature where these norms come from. And one of the Permanent Court of International Justice, in what is known as the advisory opinion on minority schools in Albania, explained why there is sometimes this specific mention of minorities in that treaty. And the court went on to say that it was important to some situations refer directly to minorities, because the only way to achieve true equality between a majority and a minority was to provide for provisions to guarantee those important dimensions of their identity. of how they describe the very essence of being a minority. So the point to retain here in the permanent court's comment is one of the core foundations of the provisions to protect minorities is actually the right to equality. That treating minority as if they're identical to majorities doesn't always work. And in fact, what we would describe that more today is that in terms of, there are situations where one law might apply to everyone, but this law may actually favor or have effects that are different on certain groups. And if you have one group, especially the minorities, which are disadvantaged or even excluded by law, because the law actually provides for, considers, for example, more a majority approach, that could possibly be discriminatory. And let me explain it by what the court said here in this case. The court said that in terms of education, and those of you who have looked at the Albania school case may know that the question was, can the government abolish all private schools? That was the question. And the answer of the court was that, well, no, you can't really. Because if you do that, that means that minorities might not be able to have education in their own language, because public schools in that situation were only using the language of the majority. So if you ban all private schools, and in the public schools, you only use the official language, minorities no longer have any opportunity to teach their own language. The law is the same to everyone, but the consequences are not. Because public schools, most public schools at the time in Albania, would only use Albanian language. And so if you ban private schools from using Greek or perhaps Macedonian, you are in fact resulting in situations where there is not equality. Because on the one hand, in public schools, the Albanians will learn their own language and gain fluency in this language. And minorities will not be able to actually teach the language to have their populations, members of their minority being able to learn their own language. So even though there is maybe one law and it applies to everyone, not everyone actually has Albanian as a language. And so therefore, by banning all private schools, you are actually not achieving equal rights or equality in practice. So the main points that I'd like to emphasize before we go to if you will, after the Second World War, is that when we talk about these minority treaties, they were not exclusively dealing with minorities. They were in fact mainly human rights documents, human rights treaties. Most provisions are universal human rights. Although today's quite a few experts would probably be uncomfortable with that, looking at it that way. But that is the proper way to summarize when you start looking at the content and you count them. You look at what exactly is protected and how this works. A few other observations here about these treaties. And it is important because even the way universal human rights were emerged and were developed after the Second World War still have some of these connections. For example, the minorities treaties were actually developed in order to try to maintain peace in Europe through the protection of the human rights of minorities, among others. Remember what was the spark for the First World War. The spark was the assassination of Archduke Franz Ferdinand by members of the Serbian minority, extremists from the Serbian minority during the Austro-Hungarian Empire. So there was this connection that yes, we have to do something for trying to address certain issues that could threaten peace. And that's when they came up with some human rights protection with those treaties. However, once again, there were weaknesses in those treaties. One of them being that they were only applied to a few countries as such, and mainly from Central and Eastern Europe, and a few from the Middle East. They only covered, they only dealt with a small number of limitations on state sovereignty, and most countries did not have to respect the same human rights. For example, all of the victors of the Second World War were not covered by these treaties. So you have a small number of weaker, defeated countries that were subjected to this and to those treaties. And therefore, did the system work? The answer is no. The system did not work because it was in fact too weak, too limited, even though they did contain a number of human rights standards. So this actually, by the time of the creation of the United Nations in 1945 and drafting the Universal Declaration of Human Rights, the concept of minority rights was completely rejected. And this is very clear when you look at the discussions, the documents, in preparation for, well, especially preparation for the Universal Declaration of Human Rights. There was debate, there was discussion. Should we refer to the rights of minorities? And clearly this was rejected. It was rejected because a number of delegations thought that anything to do with a minority was a collective right. And this was rejected because the new approach after the Second World War with the Universal Declaration was going to be a purely individualistic human rights approach. This, once again, is the basic premise for all of the content of the Universal Declaration of Human Rights. And these are individual standards that are being adopted as a new approach, and as a new approach because it was felt that the minority rights approach before the Second World War was a failure. And that actually has permeated, affected the way, certainly in the first decades after the Second World War, has affected the way we've looked at human rights and the rights of minorities. Now, that's why neither the UN Charter nor the Universal Declaration of Human Rights mention minorities at all. There's no mention. And there is no mention of any kind of, for example, in the area of language, any mention of any right of minorities in relation to their language, of course, or to education and the rights of minorities. And if you remember this treaty, the Minorities Treaty actually emphasized those dimensions. So you had a number of human rights documents before the Second World War that had many references to issues of minorities, their language, or general human rights. All of that disappeared at the end of the end of the Second World War with the replacement of universal individual human rights, and with no reference to minorities at all. However, things began to change a few years after the Second World War. A number of bilateral treaties started to appear, especially after 1955. Bilateral treaties which included provisions dealing with minorities or the rights of minorities. This is an example. The 1955 Austrian Treaty had provisions regarding the Slovene and Croat minorities. And a few years after that, we actually have the first UN treaty that once again brings up minorities as having certain rights. The first treaty of the United Nations system that specifically uses the word minority. And I mention that because in other documents, there's other treaties, The treaties really mean minorities, but they don't use that term. Because remember, at the time, after the Second World War, there really was a negative reactions whenever you talked about even minorities. But the UNESCO Convention Against Discrimination in Education, 1960, so an early treaty, in fact. It's very cautious, but it does talk about the rights of members of national minorities to carry on their own educational activities. And it does refer to the use or teaching of their own language, with also the certain obligations as such. So this treaty talks about one specific right, and it really is the right to have private schools for and controlled by linguistic and cultural minorities. It's quite timid, I would say. It's actually quite restricted, because it clearly does not require that governments provide for public schools using a minority language as medium of instruction. So because here, if you look at Article 5 and the first section here, it actually refers to the use of a minority language, the use or teaching of the language, but limited or depending on the educational policy of each state. This is really almost more permissive. It doesn't force a state to adopt an educational policy that uses for the use of a minority language, but it actually is not against it either, or it provides for it. So I mentioned this, I highlight this in particular to point out to you, as I was mentioning earlier, that there's an evolution here occurring. That before the Second World War, the minorities treaties were, many of them based on human rights standards, although limited in application. They were blamed for some of the evolution or the emergence of some elements of the conflict in the Second World War. And they were rejected initially at the time of the United Nations, that minorities should be treated especially. But in a decade or a decade and a half later, there's a very timid acknowledgement that, well, yes, there may be situations where minorities must be recognized, that they have, that their rights may result in certain things. Let me highlight the first words of the treaty. This is not a treaty on minorities. This is not a treaty on the rights of minorities. This is a treaty on discrimination in education. And what here UNESCO is beginning to do, and I say beginning, remember, human rights standards is still evolving. We're only a few years after the Second World War. What the UNESCO here is indicating is that it can be discriminatory not to allow minorities to have their own schools. That's the main point here. And this point is going to develop further as we start clarifying more what are the human rights of minorities in different areas. So on that, I notice some people are yawning. I would suggest that we have coffee, and then we can come back and continue. Because even though this may look a little bit longish, I think it's important to understand that when we are talking about international human rights norms, these did not appear all formed immediately. There's an evolution that has been occurring in terms of human rights. And that evolution today actually has come up with something interesting. Thank you. 15 minutes. Thank you very much. Let's continue. As I was saying earlier, the UNESCO Convention Against Discrimination is the first step, if you will, in the... No, I'm hearing beeping, so that was wrong. First step in recognizing that minorities have a specific place in terms of human rights documents. So this treaty makes a connection between discrimination and the right of a minority, at least in relation to private schools. Now, I wanted to also mention that UNESCO is an organization, as you may know, dedicated to the advancement of education. And just before that treaty, it actually published an important report on discrimination in language in 1953. And in that report, it had recognized the pedagogical desirability to teach children in their own language. That was in 1953, but there was not sufficient political support among governments at the time to translate that into international law in a treaty at the time. The furthest they were willing to go was this treaty in 1960. However, if we jump a little bit, especially in the 1980s and 90s, what you see, particularly in Europe, although not limited to Europe, is an increasing acknowledgement of rights specifically to minorities or to even indigenous peoples and language-specific provisions. Some of these are not legally binding, but some of them are. And I think the important dimension is to recognize that there is an evolution once again occurring. That whereas immediately after the Second World War, there is a general refusal really to acknowledge or even mention minorities, that, well, reduces or even evaporates over time. And especially in the 1990s, you know that there was, with the conflict with the former Soviet Union, the fall of the Soviet Union, changes in borders, the Yugoslavia situation, there's a growing feeling that the rights of minorities have to be dealt with specifically. If we, that actually propelled to a large degree, in fact, the treaties of the Council of Europe, such as the Framework Convention for the Protection of National Minorities, and the Hague recommendations on the education rights of national minorities. So notice that these documents don't hesitate. Not only do they talk about it, they have a provision on minorities in their title, their focus is in fact minorities. At the United Nations level also, we had in 1998, I think, the adoption of the UN Declaration on the Rights of Minorities. So during the same period, and especially in the 1990s, you have an explosion of recognition of the rights of minorities, some of which are from a clearly human rights point of view. The Framework Convention that you have here, for example, of the Council of Europe, is a human rights-based document. There's no doubt about that. The introductory report or sections actually refer to that. Notice what I don't have here. I actually don't have the European Charter for Regional or Minority Languages here in this list, and there's a reason. And the reason is that the European Charter for Regional or Minority Languages is not a human rights document. It's a treaty, and it deals with the language. Excuse me, I'm sorry, I must insist that if you're going to have a conversation, you should have the conversation outside, because it actually is a bit disturbing. Thank you. Thank you. The European Charter is a language diversity document, and this is not always understood sufficiently, I think. It explains why the Council of Europe at almost the same time had two treaties. The Framework Convention on the Protection of National Minorities actually has has many provisions that deal with language also. But how can you have, why does the Council of Europe have two treaties almost at the same time, dealing in different ways, but dealing with significantly similar areas of language and minorities? Well, because one is a human rights document, the Framework Convention, and the other is a linguistic diversity document, the European Charter. There's overlapping. There's no real contradiction, by the way, but the approach is different. The European Charter looks at language as that languages themselves have value that should be protected. It does not recognize, the European Charter does not recognize any individual human right and any individual right. Actually, it's very clear that the European Charter does not contain any right whatsoever. There's no individual, there's no collective right. No one can claim a right under the European Charter. Bless you. What the European Charter does impose are legal obligations on states. Legal obligations in terms of protecting, promoting languages, if you will. This, and I want to emphasize this, the human rights approach is interested in individuals, human beings. It's not interested in languages per se. So the focus is different, the approach is different, even though there's overlapping in a sense. Protecting linguistic diversity may mean recognizing that individuals, or may mean that individuals should be entitled to have education in their own language to protect linguistic diversity. But once again, the focus, the orientation is different, and I think one needs to acknowledge that. At the United Nations level, the focus are human rights. Under my mandate, and I will be a little bit brutal here, under my mandate, I am not interested in languages. My mandate is the protection of the human rights of minorities. So therefore, I have to look at the individuals and sometimes the communities and how they are affected. And I think this is an important dimension to understand. It's not always, I think, sufficiently referred to. Yes.
And if you are dealing only with the protection of the human rights, then you are not dealing with minorities at all. I mean, there is human rights and there are minority rights, and they are different.
I will clarify that. In terms of my mandate with the United Nations, that is not correct. And I will explain why in a few minutes. And actually, thank you for that, because that's an important point. But allow me to finish talking about this, and then we'll get to that specifically. Once again, and I want to emphasize this, when we talk about the mandate of the United Nations that I have, the mandate from the United Nations is clearly to deal with the rights of minorities from a human rights perspective. So the distinction that you make is not a distinction that we recognize or apply in the United Nations system. And I'll elaborate on that further on, but I think it's important to me to make that very clear. When we talk about minority rights at the UN, we are talking about the human rights of minorities. And I'll explain in detail shortly as to what that means.
But in this case, I mean, there is no anything what is separate, special for this group that we are calling to be minority rights. Minority rights are collective rights. Human rights are individual rights.
At the United Nations, that is not correct. The rights of minorities are individual rights. That's the way it's formulated. We'll get to that. You'll have to be patient, but we are getting to that step by step. Thank you.
May I ask a question?
Sure.
Minority, do you mean just linguistic minorities, or it can be like any, because social...
Once again, I'll be getting to that a little bit later, but let me quickly answer that. The mandate of the Special Rapporteur is clear. We are referring to only certain types of minorities: religious, linguistic, or ethnic.
Regional?
No.
In France, there are regional.
No. Stop. One step at a time. Once again, the mandate of the United Nations is very clear. It is limited to linguistic, regional, religious. Don't do this. Linguistic, religious, or ethnic minorities. Not regional. We don't recognize the concept of regional minorities in the United Nations human rights system.
Okay, now if you recognize linguistic minorities, then de facto you recognize ethnic minorities.
It's not exactly identical. You can have ethnic can refer to being descended from certain populations. You may, for example, my own example, my language is French, but culturally I am a North American, I'm Canadian. So even though I have the French language, in terms of my culture, it's quite different from France. I consider myself culturally to be North American. So the linguistic is not identical to ethnic, but there can be overlapping. Language is an important identifier of culture, but it's not the only identifier of culture. If I can use another example, I have Muslim and Jewish colleagues who will say that culturally they are Jewish and Muslim, but religiously they consider themselves to be atheists or agnostics. So, once again, culture and ethnicity, or even culture and religion, there is overlapping, but it's not identical categories. And it's quite clear at the United Nations, once again, and the mandate that I've received from the UN Human Rights Council, that we recognize these three categories in terms of what are the minorities that are protected under Article 27 of the Covenant on Civil and Political Rights. I'll mention it later, but that's the main provision, legal provision, in terms of the rights of minorities, but it's not the only one, and I'll be explaining that because it's really important, and I'll repeat this perhaps. When we talk about the rights of minorities in the UN system, we are talking about the human rights of minorities, and it includes areas such as freedom of religion. The most important right for a religious minority in international human rights law is not Article 27, which talks about the right of a member of a religious minority to practice their own religion or belief. It's actually freedom of religion. That's the human right that I refer to most often when I deal with religious minorities. That's in practice, in concrete terms. That is one of the core rights of religious minorities under my mandate and under the human rights system, because in fact that's the most important right for many religious minorities around the world. So I once again, I'm absolutely must emphasize that when we're talking about the rights of minorities, we're not, for the UN system, we're not talking only about Article 27 and stopping there. We're talking about all of the human rights that are relevant and effective for the protection of minorities. And I'll go into that in detail later. Thank you.
I did a short question. You tell about official state religion. In Lithuania, we have old Baltic religion, but his religion not registered in Justice Ministry. What kind of religion you
Oh my God. Okay. Look, we're going into details, but that's actually a good question. Let me answer very quickly. Once again, under the UN system, dealing with minorities, we are not looking at the status of minorities. We are not looking at minorities. We're not limited to minorities that are recognized in any way. We are dealing with any religious, linguistic, or ethnic minority, regardless of status. So whether you are an unrecognized religion has no consequence in terms of you still have all of the panoply, all of the series of human rights that may relate to religion or belief. So I think in Europe, sometimes in some countries, a minority must be recognized, must have some kind of status. In terms of the international human rights system, that is not the case. As soon as you are either a religious, linguistic, or ethnic minority, in the sense of being a numerically less than half the population of the state, you are entitled to the right to being dealt with as a minority under the international human rights system. Does that answer your question? Okay. Shall we continue? Yes. Now, there was a UNESCO convention, but the main provision that specifically, and I emphasize this, specifically refers to a minority under the UN treaties is this one, Article 27 of the International Covenant on Civil and Political Rights. Now, sometimes, and this actually relates to the earlier question, sometimes there is this is presented as the main or the only minority right provision in general human rights treaties. This is actually not quite the case, and I'll explain as I go along, but I think it's important to just to to refer to it and explain it a little bit. This provision is the basis also of my mandate with the United Nations Special Rapporteur on Minority Issues. And it says that in those states in which ethnic, religious, or linguistic minorities exist, persons belonging to such minorities shall not be denied the right in community with other members of their group to enjoy their own culture, to profess and practice their own religion, or to use their own language. It's actually not the only one. There's also Article 29 of the Convention on the Rights of the Child that refers to minorities in a slightly different way. It refers to, I don't have it written there exactly, but this actually refers to the right of the child to have his or her own cultural identity, language, and values. It also contains earlier, I'm sorry you don't have it there, to the children belonging to minorities also. If I go back to the Article 27, even though there is some debate about this, this has been interpreted by the UN Human Rights Committee. The UN Human Rights Committee is the committee of experts who interprets this provision of the covenant. And the committee has, in relation to the wording here, indicated that this actually involves an individual right. It refers to persons who belong to minorities under these three categories. Even though it can protect a community or a group interests, it has been interpreted by the committee decisively, in fact, that this is an individual right. And once again, remember that after the Second World War, the universal approach of the United Nations has been to recognize individual human rights. And this is the way Article 27 has traditionally been interpreted. If I can, well, this deals with education specifically, and perhaps, no, I think I'll skip that for now. To go back to your question or comment earlier, under the United Nations human rights systems and mechanisms, when we talk about the rights of minorities, we essentially are talking about two areas or two distinct groups of rights, if you will. The human rights of minorities in international human rights law, by international I mean the UN system, will reconsider issues such as general human rights provisions, especially non-discrimination, freedom of religion, and freedom of expression, as any kind of specific minority provisions such as Article 27. So to go back to the initial comment that you had, when we refer to the rights of minorities that fall under my mandate, that includes all human rights provisions that are relevant. In relation to religious minorities, this especially concerns freedom of religion or belief. It also includes very often the prohibition of discrimination on the ground of religion. And it can include other areas such as the right to private life. I'll give you a quick example. There was a case in Austria. Now this is, the judgment has been published, so I mentioned it. In Austria, where the judge determined that the custody of the child, it was a separation, divorce, that the custody of the child should go, and if I remember correctly, should go to the father because the father was Catholic. The mother was Catholic, the father was a Jehovah's Witness. And the court actually said, well, that the Catholic parent should have the custody of the child because Austria is essentially a Catholic society. Yes. And therefore, it would be more appropriate for the child not to grow up in the environment of a religious minority, but to grow up with the father whose religion is more consistent with Austrian society. I'm not making any comment here. This is in fact a judgment. That has been ruled as to constitute a violation of a discriminatory violation. It's discriminatory, and it was also an infringement of private life because it made a certain judgment. But what this means that for a member of the Jehovah's Witnesses, a member of a religious minority, it was not Article 27 or something similar to that was effective. Their right as a religious minority, or her right as a religious minority, was protected by general human rights standards. And this is what occurs in the vast majority of cases involving, for example, religious minorities. It's actually freedom of religion, or non-discrimination on the ground of religion, or another effective human rights standards. And that is why it is important to realize, and this is also contained in the Declaration on the Rights of Minorities of the UN, that we refer to the rights of minorities in the Declaration and under my mandate as all human rights that are applicable to minorities, including general human rights standards. Most cases, and I want to emphasize this to make sure it's understood, most cases involving the protection of minorities involves the general human rights provisions. It's only a relative number of cases that are dealt with under Article 27, because that's not the most effective human right for minorities, linguistic, religious, right? Yeah.
It was very interesting case in Klagenfurt in Austria several years ago. You have what is the local Muslim community, composed by all of those, and Turks and Albanians and Arabs and whatever. Now they apply to the local municipal authorities just to get permission to build for their own money the mosque. And then you have a decision by the local municipal authority, no, we cannot issue this permission. Then you have explanation, very interesting explanation why. Because if you will build up the mosque in the city, from very architectural point of view, it is going to be not, how to say, incorporated into our what was Baroque and Rococo and neoclassical architectural, those buildings around. That was simply the explanation. Simply, what concerns the mosque, okay, but you cannot build because it is oriental shape and so on. And simply, in this case, you are going to destroy what is the harmony of our, what is the European cultural and so on environment around. Mm-hmm. And that's it.
Mm-hmm. Thank you for that. Where was that? In
Klagenfurt.
Oh, yes, okay, yeah. Once again, if that were submitted to me as a special rapporteur, and I'm not commenting on that exact situation, but if that were an allegation of a violation of the right of a religious minority, I would look at, is there an issue of discrimination? Is there an issue of violation of freedom of religion? And I would look also at Article 27, there's no doubt, the minority specific. But in terms of my mandate and the human rights of minorities, I would actually first look at the non-discrimination and freedom of religion. That is the way that it works in practice most often, under the mandate and with the UN system. Almost all cases that we have of minorities are dealt first under the general human rights provisions. So when we talk, and I want to emphasize this once again, when we talk about the rights of minorities, this is not a special or a different category of rights that is removed from general human rights. This is considered, under my mandate, to be clearly a series of human rights that may be involved, including what we would consider simply to be general human rights, such as non-discrimination. I think I'll give perhaps another example. There was, well, in France, actually. In France, I was going to mention this later, but I mentioned it earlier. In France, in 2004, the UN Human Rights Committee issued conclusions in relation to the prohibition in France for students to wear any kind of ostentatious religious symbol. So if you wear a cross, that's not allowed actually in French public schools or French universities. In fact, the UN Human Rights Committee has had quite a number of cases involving religious minorities in France subjected to different laws. And in 2004, the Human Rights Committee indicated that because it had a complaint from an individual who was a Sikh, a student who was a Sikh, and because of his religious belief, he wanted to wear a turban. The Human Rights Committee looked at that situation, and in the case of the prohibition of wearing a turban or any kind of religious symbol, the committee asked the French government, well, why are you doing that? And the government gave the answer, laïcité. The secular nature of the French Republic requires us to be absolutely neutral, including students who attend. The committee actually rejected that. And it rejected that on the basis that it was an infringement of freedom of religion. And I find it surprising. I'm going to make a comment because these are conclusions that were published or publicly released by the committee. I find it surprising that we have so many cases involving religious minorities in France. We've had Jewish, Muslim, and Sikh cases in France. And the approach of the committee has generally been using, once again, either freedom of religion, mainly freedom of religion, or sometimes non-discrimination, to determine if there is a violation. I don't think the committee has even once referred to Article 27. Article 27 can be useful in some situations, but for a number of reasons, when it relates to minorities, it's more effective to actually use freedom of religion or non-discrimination in general. So I don't want to repeat this all the time, but I have to emphasize that for us in the UN system, when we talk about the rights of minorities, we're talking about all of the rights that are relevant to the protection of minorities, linguistic, religious, or everything. No, go ahead.
Your comment on the case of Switzerland, no mosques in Switzerland. It was referenda. Switzerland is, considered to be one of the most democratic states in the world, together with Norway, Iceland, and whatever. It was, I guess, no months, the referenda, the last one some 3 years ago, and the majority of those who have minority rights, the voting rights, they simply decided no mosques.
No, I think
no mosques, and that's it.
Thank you. I think once again we have to distinguish democracy and respect for human rights. They're not synonymous. They're not always the same. And that's why you have democracies that are clearly in violation of certain human rights. It happens. No country is perfect in terms of human rights compliance. And democracies are a bit better in some areas than maybe others. But once again, it's not a guarantee of full respect of human rights. We know that. And I'm not going to comment directly on Switzerland because I've not had I don't think we've issued any conclusions in relation to Switzerland. But in any event, I think the government or the Constitutional Court rejected the referendum. It was something that occurred afterwards. So the referendum was not applied directly, I think. Because there was a referendum to change the Constitution, wasn't it? And that, in the end, it was rejected for different reasons. That's as far as I can go, because I don't really recall.
But anyway, no mosques. No minarets, no mosques.
Well, once again, I don't know what the situation is.
I'm telling you, in Switzerland, single minaret and single mosque.
But once again, that does not mean that even if it's a democracy, and let me give you an example. You can have a democracy where people are very intolerant. If you have a democracy where most people are cannibals, and are all of human rights going to be respected? No, I know this is a joke, but no, seriously. You have societies right now where, in fact, and you know this, there's a growing intolerance in some societies against certain minorities. I don't want to exaggerate the analogy, but even in terms of Germany before the Second World War, Germany was an extremely racist society. Whether it was democratic or not, we can debate that. But the degree of anti-Semitism that existed in Germany was widespread. You could say that most Germans, yes, were anti-Semites. They were influenced, they were brainwashed. But you can have a majority of the population that actually is swayed often against minorities, because minorities can become scapegoats. I mean, let's be honest. There's a lot of hate speech going around against certain minorities. And people believe this for different reasons, right? Because of different factors. So you might be democratic, but it does not mean that the majority of the people are respectful of everyone's human rights. So I think you have to acknowledge that that's the case.
From the point of political science, it doesn't go this way.
Well, that's why you need human rights from a legal point of view sometimes. Thank you for that. Any other questions or comments? No? This might be a little bit, not controversial, but it's not something that you might have heard very often. Why do we have different documents or treaties for minorities, including with the Framework Convention of the Council of Europe on the protection of national minorities? Why do we have a UN Declaration on the Rights of Minorities? Does this not mean that they are distinct rights, that they're not really universal human rights? Well, the answer is they are still universal human rights, but in some areas of law, of human rights law in particular, we needed to develop specific instruments to deal with the challenges of different groups, if you will, which are more vulnerable or marginalized. We have, for example, treaties on the rights of migrant workers. Does that mean that the rights of migrant workers are a separate category of rights? They're not really human rights in general? Of course not. We deal with, in relation to migrant workers, with a segment of society that in most parts of the world are quite vulnerable. So we need to clarify the content or the consequences of the application of different human rights to the situation of migrant workers. That's what we've done also with the Convention on the Elimination of All Forms of Racial Discrimination. Notice even the title, All Forms of Racial Discrimination. Now, racial discrimination is prohibited in other treaties, general treaties. Why did we need a specific instrument, a specific treaty to deal only with racial discrimination? Is this a special category of rights? Well, no. It actually elaborates in the area of racial discrimination, which is racial groups are quite often extremely marginalized in many parts of the world. So we developed a treaty that elaborates what does it mean to apply non-discrimination in the area of race. The rights of children, the same thing. The Convention on the Rights of the Child is not a special category of rights only for children. It actually elaborates on the consequences, the application of general human rights, generally speaking, in terms of children who are particularly vulnerable in many parts of the world. And it's the same for minorities. It's no different, in fact. When we're dealing with minorities, yes, we have developed treaties, but treaties, at by and large, give substance to the application of general human rights to the situation of minorities, which in many countries are amongst the most vulnerable or marginalized. Not always. There are in some countries minorities that are dominant. True. But in many parts of the world, that's not the case. In fact, in most parts of the world, that's not the case. Therefore, that's why with the Council of Europe, we have a treaty on the Framework Convention for the Protection of National Minorities. And we at least have the UN Declaration on the Rights of Minorities at the UN level. So as I indicated, this is, once again, I go back to the concept of evolution. We've actually gone to a situation where, well, even the word minority was taboo in terms of international human rights law, to a situation where we increasingly added the word here and there to a number of provisions, leading to a situation where we developed a general declaration on the rights of minorities, but now to look at the language rights of linguistic minorities more specifically. We have had to, what you have here is our first attempt to try to bring together all of the human rights of minorities and to try to explain what it means in terms of implementation or a more practical point of view in applying this in the area of language for minorities. This is the first document, and it was released last year by the mandate of Special Rapporteur on Minorities, to try to explain what are all of the human rights of minorities in the area of language. And it actually is, once again, a human rights document. It says so, and I invite you to get copies of this document. Clearly, for us at the UN, Natasha, I'm going to lose my English as we progress. We connect the language rights of minorities to specific areas of human rights in general. And to try to give shape to that, this is our first attempt. It's still rather general, but it is considered, or it is described as a practical guide for the implementation of the human rights of minorities in the area of language. And although there is no universally accepted categorization way to organize these human rights of minorities in the area of language, what the guide proposes, in a sense, is to look at language rights in this type of organization or structure, if you will. First of all, in the application of a number of human rights that are described in the guide, when you have the issue of the private use of a language, this is considered to be a form of covered by linguistic liberty or linguistic freedom. Generally speaking, I'll elaborate on that in a few moments, individuals are free to use a language of their choice. It's under freedom of expression. Sometimes it can be other areas. The language of their choice in private activities. There's linguistic freedom connected to freedom of expression and sometimes even freedom of association. In terms of the judiciary, what we refer to, or some of the basic concept or approach, is that of fundamental fairness. You know, for example, that in criminal trials, an individual who does not understand the language used in court has the right to interpretation in the language he or she understands. Not necessarily his or her language, but a language they understand. So it's a form of language right, actually, but it is connected to the concept of procedural fairness that is recognized in different treaties in international law. And finally, and this is the most complicated or the more complex and even controversial area, is the use of a language by state institutions. Not a private use of the language, but are there situations where the government must use a minority language or other languages even? And the answer that is provided, or the guidance that is provided in the practical guide that you have here, is that there are indeed situations where there is a human right to the use of a minority language in application of the principle of proportionality. I'll elaborate on that in a few moments. So authorities, by that is meant public authorities, there are situations, there are circumstances where, yes, other languages must be used in addition to an official language, for example. And this is, once again, based on the interpretation of a number of UN bodies, committees, and others also over the more recent years. Now, one of the aspects of the document, once again, that should be noted is that this is a very recent document. And most of what it refers to as the language rights of minorities are part of a relatively recent evolution. In other words, it's really about the last 20 years that you are beginning to have jurisprudence at the international level that actually deals directly with the issue of language. Language in private use, language used by public authorities. The area of the judiciary, there's been more longer tradition, if you will. but there has been, especially in the last 20 years, an increasing acknowledgement and recognition of the impact of various human rights in the area of language use. Now, if I can look at, to explain a little bit, beginning with linguistic freedom or linguistic liberty, this area is not controversial now, or it should not be controversial. It's very clear from the jurisprudence of the Human Rights Committee and others now that private use of a language is guaranteed. There might be a few exceptions, but generally speaking, you cannot prohibit, for example, if I'm walking in the street, could the government make it a criminal offense for me to speak French when I walk in the street? Now, I notice some of you are smiling, but in fact, there are historical examples of it being a criminal offense to speak certain languages. In Bulgaria, it used to be an offense to speak Turkish. You could be fined for speaking Turkish during a certain number of years in Turkey. Now today, this is very clear that this would be a breach, a violation of freedom of expression. Using a private language in a private context is a linguistic right protected under freedom of expression. It's, by the way, a linguistic right that applies to everyone, but in practice, it's really linguistic minorities whose right might be violated in most parts of the world. Yes?
I also just add an example of Lithuania, and Lithuanian language was abolished in history from 1840 to 1994.
Yeah.
So it was like majority Lithuanians were minorities or Lithuanians,
Yeah.
and we were also not allowed to use Lithuanian in the characters. So
In private use?
We couldn't use like a language at all. It was Russian language.
Okay.
It is not correct. This is not correct. How old are you?
No, excuse me. I'm not sure. I think I heard a word that was not very nice, but I'm not sure. I think it's important to, once again, to make the distinction. We're talking about private activities. You have to focus, you have to divide the world in, and it was difficult, the world in private and public. The private use of a language, not many countries actually had governments prohibiting the private use of a language. Some. And I'll give an example. In Canada, one of the best countries in the world. Why are you laughing? It's actually true. And in the province of Quebec, at one point there was legislation that said all commercial signs must be in French only. These are private signs. That's why it's important to make this division. Private. And the question went to the United Nations Human Rights Committee. And one of the questions was, is this a violation of the human right of those people who do not want to use French or want to use Chinese or English? And the Human Rights Committee said very clearly, the use of a language is part of expression. If you prohibit individuals in private activities to use the language of their choice, this is a violation of freedom of expression, unless it's permitted under the permissible restrictions in international law for freedom of expression. And in the situation of Quebec, the committee said to completely prohibit the use of all other languages is a violation, is not reasonable. I mean, it's clearly a violation of freedom of expression. I don't want to go into quite a lot of details, but it is interesting because the committee said, in Quebec, we recognize that French is the official language. This was in Quebec. And the law only allowed French in private activities of that nature. And it is appropriate to take measures to protect the French language. And it is appropriate that French be used, but you cannot stop the use of other languages. So the appropriate understanding of freedom of expression in private activities was, according to the committee, this was applied by the government of Quebec. You must allow other languages to be used. my affairs, my private life, my private business, I can use the language of my choice. But because French is the official language in Quebec, and it's important to protect the French language in that part of Canada, it is not a violation of freedom of expression to require, in addition to your language, that some French be used also. I think that is a very good decision. It is consistent with the content of freedom of expression, whereas it recognizes the legitimacy of also requiring the use of the French language there in terms of protecting that language. But that's clearly private. I think your example really was more to generally by the use of the Russian language by public authorities, which is different. That, just to go back, that would be the use of minority language by authorities. That it's not the principle of linguistic liberty, but it's the principle of proportionality. So really, you have to divide the world in two. Private activities, very simple, freedom. You cannot be stopped from using any language, although sometimes you could be required to use another. But when you're dealing with public authorities, the government, the institutions of the state, it's a different principle connected to principle of proportionality, and as I'll explain there, other human rights norms, especially non-discrimination, others in some cases. Okay. Now, I had Lukasz, Monsieur, and then Monsieur. Lukasz.
I just wanted to clarify. So, advertisement of a company and everything which is in the company is seen as a private matter?
Yes.
Because I understand in Lithuania it's not the case because companies have been fined for using non-Lithuanian language, like on the advertising the business.
Okay.
So there's inspection coming with fines if you use more than language on the windshield.
Mm-hmm.
So would this fall under the same?
Thank you for that information. I'm not going to comment directly on that because I'm not here on an official mission. This is an awareness-raising activity, and I'm raising awareness of these rights. And especially because if ever I receive an allegation, a letter of allegation that there might be a violation or breach of the rights of minorities, I have to make sure that I have a balanced, neutral approach to that. So I would not want to comment on any kind of situation here, and but I would look at any kind of situation which might involve violations of the rights of minorities. Monsieur, et then Monsieur. Yes.
Merci.
De rien. Vous parlez français?
A little bit.
Okay.
I need to say that I notice a problem of difference of understanding of human rights and some basic law philosophy in Europe and the UN. I will elaborate in an easy accessible way. For example, here, when we talk about some people would like to combine human rights and the democracy together, which is often the practice in some Asian countries, for example, in China, Japan, or some other areas. But here, I feel that first, we all agree that the linguistic right is an emerging area. It's a relatively new concept, comparing to, for example, anti-discrimination on ethnic minorities, right? Let me talk about two cases. One case is in the Wrocław of Poland. There was a sentence, hate speech. A guy drunk swears and threatened to give physical contact on a sales woman who was Ukrainian but tried to communicate with him in Polish. The sentence by the local Wrocław court was to label it hate speech against ethnic minorities. But the situation is that the spark is the language, because that Ukrainian staff was new in Poland and she didn't speak very fluent Polish. She had strong Ukrainian accent or maybe Russian accent. The situation was mainly dealt with the discrimination of ethnic minorities. not linguistic minorities. I feel the situation is like kind of behind. It's kind of here in Europe, people more emphasize on the harmony of ethnic relations. We are a union, we are European Union, we must be in solidity to be together. And this is kind of legal philosophy, in my opinion. And they sometimes influence the jurisprudence or the interpretation of the law. But in UN, this lecture, I feel really delighted to know, because I learned some new perspective of understanding the whole picture, that you are from the more abstract, like individual human rights and its practice not based on very specific principles, for example, so-called European value. And the second case is a jurisprudence done by Strasbourg European Court of Human Rights, maybe this year or somewhere last year, not very far from here. The decision was that the usage of Russian interpretation on a case related to a Lithuanian citizen was a violation of human rights. Maybe some of you heard about it. The case is Lithuanian made some things wrong in Slovenia, in Ljubljana, and the sentence, the jurisprudence was done in Slovenian, but he didn't understand, so the interpretation was in Russian. Although he requested whether it could be done in Lithuanian, the decision was that this was a violation, because he is Lithuanian, not Russian, and Russian is like kind of discrimination to say, well, your robotics was part of Russia, Soviet Union, and you must understand Russian, so I use Russian, which is easier to find than Lithuanian interpreters. So I think this is kind of so-called European value of some current political situation playing a role. So is this clear?
Yes, thank you. Thank you. May I say it's important to understand that when we talk about the United Nations human rights system, we have to be as objective and neutral as possible. We cannot accept arguments of Asian values or European values to set aside somehow universal standards. And I think that's why I don't want to go into too much details. I think that's why you're beginning to see a divergence between the interpretation in Europe in some areas and the interpretation at the UN system. One quick example, the area of religion. Very clearly, freedom of religion, often involving minorities, is interpreted in the UN system very differently from the European one. It's actually, I won't say it's, well, in fact, it is contradictory. So there is, for different reasons, the European Court of Human Rights is interpreting freedom of religion very, very differently from it. The same situations, almost identical situations, are interpreted in the UN system for different reasons. One of them being that the human rights standards that you have in European treaties, such as the European Convention on Human Rights, is actually not identical to the human rights standards that we have at the UN system. So if the wording, the words used in your treaties here in Europe is different from the treaties in the United Nations, you will not always get the same results. And this is what we're saying. But once again, because we are a universal system, we cannot we cannot simply accept the argument of European values or Asian values, by the way, but we will actually look at what are the standards, the norms that are to be applied from an international universal point of view. And I'll answer it like that. Just perhaps one more comment. Yes, it's true that if we look at the content here in this guide, a lot of the interpretation, the conclusions or the decisions are relatively recent, but the norms that are involved are not. Many of, especially in the area of linguistic freedom, we're talking about freedom of expression. Freedom of expression is a basic fundamental human right that is not long-standing. It's been there for a long time.
Yeah.
The only thing that is new is that it's only relatively recently that we've started to look at what it means in relation to language specifically and such. So just to add that.
Let's see, in Europe, there is a common value that each language has its unique feature and must be preserved. This is also common practice in China. There are some ethnic minorities has their languages, and they are specially recorded and make textbooks for them. Even they prefer to use Chinese or other languages to learn the scientific knowledge.
谢谢. But I think we have to go to other questions. He had another question.
Oh, sorry.
No, that's fine. And that was Mandarin, by the way, for those of you who don't know. I've taught it in Peking University, Beijing University. So I actually have spent some time in China also.
Okay, then you were speaking about what is the private sphere and what is the public sphere, and the linguistic rights of those minorities. And then, as I know, from those textbooks, whatever, it is recommended very strongly what is like United States of American system, that in the private sphere, all of those languages are allowed and so on. And then you have to switch to what is the public sphere.
Mm-hmm.
And then this is something different, what you have to use the language of what is considered to be the official language in the public sphere. But then my question is, what to do with those cases, with those states, in which even today, as I know, maybe I'm mistaken, the case of Australia, the case of the United States, no single law, either constitutional or any other law, regulates what is the official language of the country.
Okay.
And then this is, well, you can speak on official place, I mean, even with the government, in the parliament, in whatever you want, the language and dialect according to the law.
No. Just briefly, even though, for example, in Australia, there's no law that recognizes English as the official language, that's true. But Australia has the common law system. And that means that there is actually jurisprudence, cases going back to the 17th century, I think, which indicates that the language of the institutions of government is actually English. So even though it's correct to say there's no legislation that makes English the official language of the country, the common law has been interpreted for hundreds of years to mean that the government works in the English language.
And this is interpretation.
And this is court, this is common law. And remember, in the common law system, there are two sources of law. There's legislation, but court decisions are also an independent source of law. So court decisions are legally binding as law, even though there's no legislation. So that's why we have to be careful. There's no legislation that recognizes English as the official language, but there is common law that recognizes English as the language of government and the machinery. In relation to the United States, I'm happy you mentioned that, because there is also, it was pointed to me that there's a human right to coffee. But in addition to that, in the United States, yes, there is no legislation that makes English the official language for all of the countries. However, once again, it's a common law system. And there is, going back to the 17th century, court decisions that make English the language of the court and government. But, and here's the interesting part, there's legislation. It's legislation on equality and the prohibition of discrimination. I think it's chapter 6 or chapter 7 in the United States that requires the use of minority languages in areas of federal activity. That's surprising. So you actually have a right, for example, to electoral material in federal elections translated in the language of minorities, where in a electoral district, small territory, in the district, if you can identify more than 5% of the population of the district that share the same linguistic ethnic background, there's a legal obligation to use that language for electoral purposes. So you go to California. There are many electoral districts in California where they have des pancartes, signs, official federal government signs. Vote here, vote aquí, in Spanish. And they have it also in Chinese.
Not in Chinese, in Vietnamese.
And Vietnamese also, but also Chinese in some districts.
No. I'm sorry, this is not true. I was myself in the Silicon Valley area, and there were 3 official languages there.
Yeah, sometimes there are 3. But there are different districts. If you were in one part of the country, in some other parts, other districts, you have other languages used. There are actually even 2 districts, and once again, someone is telling me it's coffee time. There are 2 districts in California where they use Farsi during federal elections. Why? There's more than 5% of the population in 2 districts in California, where there are more than 5% of people who are Persian background. And this is enough to actually have the right to use the minority language for federal electoral purposes. And I think that's interesting. It's actually connected to non-discrimination, and I suggest to you it's connected to the principle of proportionality. It's reasonable and justified to use some languages where there is a certain concentration of individuals who have a different language. And on that, you have the right to coffee, as do I, and then we'll come back. Ladies and gentlemen, if we can continue, I'm happy to report that the end is near. We're doing very well. I appreciate the fact that most of you are still here. And it is a long day, but I think we've made quite a bit of progress. However, linguistic freedom is the easy part. What is much more complex and still in the process of being clarified in terms of our understanding of what it means is the application or the extent of language rights in the public sphere, by the use by public authorities, by the government, in public schools, government services, healthcare, public healthcare, and so forth. Because when you're dealing with language rights that impose an obligation, a positive obligation on state authorities to use another language, well, that really can be the most contentious and consequential. I mean, it has impact, it has effects for both policy makers and rights holders, individuals. On the one hand, there are many different reasons or factors where there are legitimate concerns and limitations of practicality and expenditure, resources for authorities. You cannot use, no government in the world can use all of the languages spoken by everyone in their country. So you can't simply say that there is a right to use minority languages in every situation. That's impossible. It's not practical. So there has to be some kind of, well, first of all, it has to be a human rights standard norm that you can raise, you can invoke in relation to claiming the right to have a service, a public service in a non-official or minority language. And secondly, how does that work in effect? How does that actually is to be applied? What has been happening is that more recent human rights decisions suggest that a state language preference, even when it relates to the official language, which is unreasonable or unjustified, can constitute discrimination. And here I am suggesting to you that in terms of the use of minority languages, minority or any other language, in some cases, it can even be the majority language, by the way, that is not used by the government. Now that may sound strange, but in fact there are countries where this is the case. There are a number of countries in Africa where the official language is either French or English, but it's not the language of most people in our country. It's rather ironic. So even though I emphasize here the language rights of minorities, because the main human right that seems to have an effect is actually the right to equality without discrimination, this actually also applies to the majority language. I'll give a quick example. In South Africa, the largest language is actually Zulu. But there's almost no use of the Zulu language by public authorities. Now, I shouldn't comment too much or shouldn't go too far, but the general principle of discrimination would suggest that in some areas, not using Zulu is not reasonable. When everyone speaks Zulu, when even the government officials speak Zulu, to say that you can only use English, for example, it's probably unreasonable, probably, not making a definite conclusion, but probably not reasonable and justified to prohibit the use of Zulu in certain circumstances. And that suggests that it could be discriminatory in international law. It's normal to have linguistic preferences. Governments must have linguistic preferences. It's impossible not to operate with a language. But there may be situations where it's unreasonable not to use another language in certain circumstances. One quick example, sign language. Remember I said sign language is a language, therefore we are dealing with linguistic minorities. If you have a country which says only English can be used, and that actually could mean that you're not allowed to use sign language. I'm pushing the example here. Not to use sign language where it's possible to do so, and where you might have an urgent situation, for example, public health. To have a prohibition of any use of all other language, prohibiting all other languages, including sign language, I think would be clearly unreasonable in terms of someone having a medical emergency in a hospital, public hospital. It's not reasonable, it's not justified to prohibit sign language. And once you say that, what you're saying is that the law, even if it applies to everyone, you can only use English. The law actually has such a serious and negative effect on individuals who are deaf that it cannot be reasonable, cannot be justified. It would very definitely be discriminatory in international law. And that is beginning to be the conclusion in a number of areas. There has been some documents, and here I'm speaking in a more general sense, documents that would suggest that it's not a proportionate approach, it's not a reasonable approach, it's not justified if you don't use other languages in areas such as decision-making or public participation process. Access to public services, especially in areas that are important or have serious consequences for individuals, such as health or social service. It has been recognized it's most effective when offered in the language of the individuals. So where possible and feasible, minority languages should be used in public health to the degree possible. And I'll connect that with specific examples in a few moments. Education in a minority's own language, for example, results generally in better academic results, and including the learning of the official language or the language of the majority, particularly for vulnerable segments of society, including indigenous peoples and even women. There are studies, just mentioned quickly, studies done by UNESCO indicating that particularly with indigenous communities, and indigenous communities, as I was explaining earlier to someone else, indigenous communities or indigenous peoples can also, in some countries, be a numerical minority. So one does not exclude the other in terms of international law. A number of UNESCO studies have shown that using indigenous language increases the presence of young girls, young indigenous girls, in the educational process. For a number of reasons, in some indigenous communities, women, girls, can be more isolated, may not have as many opportunities to learn the official or majority language. So what happens in these communities is if you only teach in the official language, let's say Spanish in Latin America, indigenous girls actually are less fluent than young boys, because young boys go out more. They might actually have more exchanges with individuals who speak Spanish. So the studies demonstrate that only using Spanish in indigenous communities actually excludes, marginalizes young girls more, young indigenous girls more in education. And when you use indigenous language in education, young girls actually succeed better. So there is actually a gender dimension sometimes in the situation of using a minority language or an indigenous language in education. And I'll go a little bit more in detail in a few moments. There's even issues of economic and employment opportunities connected to the use of minority languages. Quite a large number of countries, and this is to look at practice in some countries, quite a large number of countries actually have a proportional approach in the use of minority languages in public services or by the institutions of the state. And by that I mean, if you look at the practice of countries, a great country like Canada, of course, as I mentioned earlier, but other countries like Belgium, Italy, even India also, Bolivia. Bolivia is an interesting example for different reasons. Ethiopia and Switzerland. They use more than one official language. But they don't use all the languages in the same way. By the way, that's impossible. Bolivia has some, if I remember correctly, around 50 languages, 50. Are all those languages used in the same way by the government? The answer is no. The government of Bolivia has essentially a proportional approach. In relation to the largest linguistic groups, the Aymara, the Quechua, and there's a third one, which is the largest, I forget the name now, and Spanish, of course. So the main language, or language used by for public services, is Spanish. But there's guarantee also use of the main indigenous language in a proportionate way, especially where those languages are concentrated. And in fact, recently, the government of Bolivia has established 3 universities, public universities, that teach in these 3 indigenous languages. Not completely, there are some programs that are in Spanish, but that approach is a fair, reasonable, and proportionate approach to the use of a language of a minority or indigenous people. The Aymara and the Quechua are a very, very significant proportion of the population in Bolivia. Therefore, to reflect the reality on the ground, to reflect also the concentration, the numbers of individuals who use these languages, there is a significant, very significant degree of use of especially Aymara and Quechua. And other languages, well, depending on their size, their concentration, lesser use, but some use at the level of certain health and public services. So what I'm trying to suggest to you, and I want to emphasize this, is that you should not consider the application of human rights in the area of language for minorities to mean you must treat every language the same. That is completely wrong. What we are dealing here with generally is the application of non-discrimination, which requires a reasonable, proportionate approach to to the number of individuals, concentration, even tradition, in a sense, and other structures might be in place to determine what is reasonable and justified. That's why, to go to the example of Canada, you all know that Canada is an officially bilingual country, right? French and English. French minority is about 23%, I think now, of the population of the whole country. But that's actually not the only official languages. Those are the official languages at the national level. We also have official languages at the provincial or territorial level. The province of Quebec, it's a federation, so the province of Quebec has French only as the official language, but there are also services for the English-speaking minority in Quebec. There is a territory called Nunavut. It also has a territory with its own government, and the majority of the population there have the language Inuktitut, it's an indigenous language. And this is the official language, the main official language of the territory of Nunavut. There's also English and French, so there are 3. There's other territories there's another territory that has 9 indigenous languages as official languages, although the use of these 9 languages is quite minor. In other words, the number of speakers of these languages is actually quite small, or relatively small, which means that in practice and with the proportional approach, they're not treated the same as English or French. But there are a number of areas where you can use these relatively minor indigenous languages. Overall, I would say that the approach in Bolivia and Canada, and in Belgium, and in Switzerland, and in India, and in Italy, and Italy has more than one official language at the regional level. All of these have a general proportional approach to the use of language in terms of public services and so forth. Some of you may know the situation in Italy. There are a number of regions with more than one official language. One of them is Südtirol and Tuangini, which is in the northern part of Italy. And where the main city, the capital, is Bolzano, Moncton. The two main official languages are German and Italian, but it also has a third official language that people forget, Ladin. Very small. But what is important to remember is that not all of these three official languages are treated the same. There's a greater use of the German and Italian language. And Ladin actually has much smaller use of the Ladin language because it's actually quite small. So a proportionate approach, a non-discriminatory approach, says that this is the way you have to go. You cannot treat Ladin the same way as you can treat German or Italian. Those are the general principles. And why would, I'm going to give the example of in the area of education, a very concrete example of how you could apply perhaps a non-discriminatory approach and what it means. Interestingly enough, even the World Bank, by the way, it's not often the World Bank will make comments that we can apply in the area of human rights. This is one of them. The World Bank actually pointed out in a report on education that when you're not using the language of children in education, this is around the world, this is a global report. That's one of the main factors in the exclusion of children, or that children have bad results actually in education. If you teach children in a language they don't understand, or don't understand well at the beginning, what do you think happens? They don't do well. They fail. They are excluded. So what the World Bank has pointed out is that 50% of the world's out-of-school children live in communities where the language of the schooling is ever used at home. Many other reports actually confirm this, especially in the younger years. If you don't use the language of the child in education, they don't understand the teacher. They do very poorly. They are excluded, and especially studies in Africa and parts of Asia and Latin America show this. There is a very high dropout rate. Children drop out of school, often after only 3 years. It's quite amazing. I shouldn't do this, but I will. I'll give you one example. In Burkina Faso, in Africa, there are reports that indicate that Burkina Faso has one of the highest rates of illiteracy in the world. People cannot read or write. What some reports indicate also is that Burkina Faso is the country in the world with the greatest language disconnect. And by that, I mean the language of education is not connected to the language of the home. The official language and the only language used in education in Burkina Faso is French. And I can't remember the exact statistics, there's only around 25 or 30% of the population of Burkina Faso who are fluent in French. So think about what that means. Burkina Faso has one of the highest illiteracy and dropout rates from school, because the language of the teacher is not the language of the child. The World Bank describes this as a legacy or non-productive practice that leads to low levels of learning and high levels of dropout and repetition. There are a large number of studies, especially by UNESCO, that confirm this. In pedagogical terms, the best academic results are when you teach as much as possible, as long as possible, in the language of children. Actually, and this might sound counterintuitive, it may not sound logic at the beginning, but UNESCO reports, and UNESCO is the agency dealing with education at the international level. UNESCO reports indicate that the best way for a child to learn a foreign language or a second language is to make sure that child first has a solid foundation in his or her own language. I am, I think, a good example of that. English is not my language. I learned English as a second language, as a foreign language. I come from a community which is French, completely French speaking. All of my education was in French. However, I acquired a very solid foundation in French, and the number of hours of English we had every week in school, I forget now, 4 or 5 hours of English every week, was sufficient for me to acquire I think, a good fluency in English. In fact, I write better English than a lot of English-speaking people. And this is not a joke. This is actually serious. Why? Because I learned the proper structure of phrases, sentences, vocabulary, better than a native English speaker quite often. But I was educated in a minority language, completely. And my first university degree was in French only. And this is actually confirmed. If you really want children to learn well a second language, you need a solid foundation in the first language. And then, when you add to that, in later years, very good approach, pedagogical approach, to the acquisition of a second language, that is where you have the best results for multilingualism. These types of results, the negative results of not teaching the language of the child, is important in terms of determining if you have a situation which is discriminatory or not. It's important because if you have public education that is not provided in a child's language, this could violate the right to education in connection with non-discrimination, especially because children are affected in a negative way. The question has to be, is it reasonable and justified not to teach in the child's language? Because we know clearly from the studies, the evidence, the scientific data, we know that children will be negatively impacted by not being educated in their language. So the question is there a good reason not to do it? Is there a practical reason? Yes, in some situations there are. If you have a minority which is only 100 people in the whole country, only 100 people in the country that use a minority language, is it realistic to require education in their language? The answer is no. In other words, it's not unreasonable or unjustified not to teach in that child's language because it's not practical. So because it's not practical, it's not unreasonable to not offer education in that child's language. There is no discrimination. There's no violation. And this is the beginning of this norm, the way we should understand it, and the way that it's beginning to be interpreted, as I'll be explaining in a moment. Yeah.
I have counter, example. I was in the conference in Moncton in 2000, and then I was speaking not American person. It was the year of 2001. Now, she told me this way. In South California, this American part of California, the government of California organized the referendum for those Spanish-speaking people, who are speaking Spanish language as the main, mother tongue. Now, the referendum was going on this way. The question, do you want that your kids who are going to primary and secondary schools to get education in Spanish language? And then the people, not the kids, but their parents were voting. And then results were very, strange. Majority of those parents, they voted no, we want in English. And then it was, from University of Pretoria in California, they went there to proceed to search for the case, what is now the reason. And then majority of those parents who voted no for Spanish, they gave very practical explanation. What we want, that our kids will be absolutely fluent in English language because it is of extreme importance tomorrow, when they will finish what is the level of education, to run for the jobs. Very practical consideration. The government offers them if you want Spanish, okay.
And I think, thank you for that. I think we also have to keep in mind that there are, and I don't want to go into the details of this, there is quite often a difference in attitude and approach when you're dealing with migrant populations. Most of the people that you're referring to in that referendum were in fact migrants to California. And for when you are an immigrant, most of the time, an immigrant, the first priority is to absorb the majority culture and language as quickly as possible. So I understand, I know the example you're referring to, but I think we have to understand also that the situations involving immigrants is not quite the same as situations involving indigenous peoples, for example, or what you would call here in Europe, national minorities. So yes, that this is true what you said exactly, but there's a bit of a nuance and another factor that we have to take into consideration. In the United States, for example, indigenous people insist on having some education in their language. Why? Well, because it's a different kind of group. So there are different dynamics that we have to keep in mind when we look at these situations. So thank you. Thank you. Any other comment, questions? We still have some time. Perhaps once again to emphasize why I think, and in practice it seems to be the direction that we're going in terms of international human rights, why non-discrimination in particular seems to be an important norm, general human rights norm, when we talk about the use of a minority language in education. Whenever a government preference has a negative impact, there's a potential that this could be discriminatory. Maybe it's not, maybe it's justified, but at least as soon as you think negative or a disadvantage, you have to remember that there might be a situation of discrimination that could be possible. And in the area of education and language, it's very clear that there are negative or disadvantages in not teaching in the language of a child. For example, just to give a series very quickly, minority children who are not taught in their own language in public schools might, on average, repeat more often. They'll fail the grade. And once again, there's a large number of studies, research by UNESCO in particular, in this area. They repeat schools or grades more often. They drop out of school more frequently. Once again, very significant evidence of this effect. They have worse results. They can end up later in life with the lowest paying jobs, particularly in some Asian countries. They may not be, did you get the photo? They're not exactly treated without distinction because there is a difference in terms of language. When you teach in a public school in one language, not all children are treated the same if it is not their language. Remember that. That's where you get a difference. And if there is a disadvantage connected to that difference based on language or religion or culture in some cases, you have to ask whether or not this is reasonable. Now this, once again, this may sound a little bit counterintuitive, but education in a minority language is more cost effective. It's more cost effective even if it costs more. Yes, you want me to explain that, or is it clear? It's clear. Okay. But
as we will be careful, let's say we will have lower poverty rates, we will have less unemployed people, and of course maybe I will sound a little bit emotional, but if we would return to the previous slide, the colleague was making a picture of that. Yes, exactly. So let's say our official, I'm speaking now on behalf of Lithuanian citizen, but actually I'm graduated from Russian school. I'm teaching at college and university in English and Lithuanian, so similar situation in some ways situation. So the official position or the escalated position, but if you will finish minority school, Russian or Polish, you will ended up with lower paying jobs, blah 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 blah. Yes, so it's really pity to hear that, but statistics you presented are absolutely opposite.
I'm happy to hear that you understand this, because this is not the issue of cost effectiveness is not one that is mentioned very often. But there are a few studies that actually demonstrate this. If you invest, even if you pay a little bit more for education in a minority language, and usually when you teach in the minority languages, there are extra costs, maybe translating books or whatnot. But in the end, you get better results. So children stay in school longer. If, for example, you don't teach in the minority language and the children drop out of school, you've lost your money. Let's put it that way. So spending $1 million, but children drop out of school sooner or they have worse results is actually a loss, or it's not very effective, cost effective. But if you pay a little bit more and children stay in school 6 years or 7 years or 8 years instead of dropping out after 3, your money actually has gone much further. It's more cost effective. And this is, this is an area, as I said, it's quite interesting, but it's not fully explored yet. There's not a huge amount of research on this. And this allows me to make a bracket, a side comment. This is still an evolving area of international human rights, especially in relation to public education and the language of minorities, which is why, as part of my mandate, next year, we're going to focus on education and language. And we will be organizing, we will begin with 3 regional forums around the world, one in Asia, one in Africa, and one in Europe. It will be in Brussels in May of next year, focusing exactly on the issue of education and language for minorities in a way that's never been done in order to try to elaborate even more practical guidance and indications of what it means to apply human rights in this area specifically. We have never done that at the United Nations. We haven't done that. We intend to do that with this regional approach, and all of the ministries of education of all European governments actually will be invited, as will NGOs and research centers focusing on education and language. So it's a major endeavor, but this is important. There are consequences for literally millions of people around the world. Remember, this is an international mandate, and hopefully we'll be able to develop clearer guidelines even than the general document that you were referred to. The language rights of linguistic minorities is the first practical guide, but it's still quite general. So we intend to develop much more precise indications of what it means to apply human rights in these areas. And this is a matter of priority because, once again, a lot of this has developed recently, many areas of uncertainty, and I think clarity would be helpful for everyone, including governments.
When we're talking about children's rights and non-discriminatory practices, and also focusing on Europe, regarding increased mobility over the past 10 years, and also the so-called refugee crisis that has hit Europe, wouldn't it make sense to focus on all groups that could be discriminated in a linguistic way, and not only traditional national minorities or so-called minorities, whatever the definition is?
Thank you. Absolutely, thank you. And I'll add, now you have to realize that I'm speaking about this in a general way, and there are different nuances or elements that I may not be addressing directly. For example, it's very important that while recognizing the right, for example, in some appropriate circumstances, that children should be taught in their own language, that children also learn the official or majority language. Okay. That's also in there in international documents. Now, in relation to refugees, or individuals who are more recent arrivals, for example, there is also some jurisprudence, including in countries like the United States, that indicated that for more recent arrivals, it's a Chinese case actually. I think it's Yu Peng. Anyway, it's a decision of the Supreme Court of the United States that indicated that in the case of immigrants, in order for them to learn English, you have to take additional measures, including teaching in their own language, so that they could learn better to acquisition. English as such. And the Supreme Court of the United States used non-discrimination, equality, to arrive at that conclusion. And to apply that to the situation of refugees or immigrants, simply taking a refugee child or an immigrant child and putting that child into a normal class, it's not that. You actually need additional specific measures that correspond to their pedagogical needs. In other words, you need to teach them, let's say, Lithuanian as a foreign language, and not just put them in a class where everyone is fluent already in Lithuanian, because what you will get are, in fact, failures. So that's one dimension I haven't referred to, but that's actually a very important one, recognizing some jurisprudence.
Yeah, I'm very interested in that topic because I'm a student of social linguistics and political linguistics in Europe. And I'm just about to write my MA thesis on so-called migrant children in Germany and their equal treatment in the education system, because studies have proven that they are still discriminated among other factors in terms of language. And my question to you would be, how would you claim children's rights to those measures that you mentioned that the German government is actually not taking in supporting them with learning?
I'm not going to comment directly on the German situation, as I explained earlier. However, I think what in a number of countries, and I think in some parts of Canada, I think it's the practice, and in the United States, in some parts, I think, what is a better approach is an immersion approach. For children from different backgrounds that they don't have, especially immigrant children or refugee children. You have to teach them Lithuanian or another language, which takes into account that for them they have either no fluency or it is a completely alien foreign language. And therefore, a specific immersion approach might be the most effective if you want to try to integrate them into the educational system as quickly as possible.
I'm a social linguist. I have my own ideas about what would be the best thing to do. My question would be rather how to legally claim those rights.
Oh yeah, no, it would be discriminatory not to do so. Once again, the approach, you have to look at what is practical also, but simply putting children with no fluency, let's say they're refugee children, no fluency in a, I'll say, Lithuanian class, that child is going to do very badly, if not fail completely. And because if you're creating situations of disadvantage, you have to remember what I said earlier. Is there a situation of disadvantage? And the answer is yes, this could be discriminatory. What would not be discriminatory, that's something else. But automatically you should have this reaction. Is putting refugee children immediately in classes where they have no knowledge of the language of education creating a disadvantage for them? And the answer is?
I'm not sure if I agree with your statement. I think
I think you have to read more UNESCO research.
I'm reading a lot of UNESCO.
Well, you're not reaching the right conclusion. The evidence is quite clear.
I can agree on having different opinions.
Well, we can talk about it later. But the evidence is quite clear that you have to take additional measures, as the U.S. Supreme Court also did. I mean, if the U.S. Supreme Court agrees that it's discrimination not to take special measures for immigrant children to learn the majority language, because the U.S. Supreme Court is not known as necessarily very liberal in some areas. Come on.
I'm talking about the case of Germany.
Well, no, I'm speaking general. I don't speak about the specific countries. Okay, we can talk about that later. Monsieur and then Monsieur.
And what concerns integration, the one approach is that those minorities, okay, you are giving for them education in national language, mother tongue, but also they have to learn what is the majority language, what is the official language for their integration and so on. Now you have, as you want the cases, that you have the regional case, which means the provincial case, in which, for instance, basically what is on the national level, minority is majority. And then you have such, I mean, not approach, philosophical or whatever legal, but even in the practice, that both groups and majority and minority they are learning other language in order to be, how say, integrated with each other. To give you just example, in Serbia, in the northern part of Serbia, Vojvodina, you have the Hungarian majority in certain regions, and both groups, and Serbs and non-Serbs and Hungarians, they were learning what is the Serbo-Croat language and Hungarian, and many of them who are not Hungarians, they are more or less fluent in Hungarian, because it was such kind of law and the practice. And the logic is that both groups has to be, how to say, integrated. Let's say those minorities on the national, federal level are majority, basically minority in certain regions, to be integrated with those regional minorities who are basically majority in this region.
Thank you. In the case of Quebec that I mentioned earlier, for example, even though in Quebec the official language is French only, and education is a provincial jurisdiction, so it actually depends on the government of Quebec. Members of the English-speaking majority, Canadian majority, who live in Quebec, actually have the right to education in their language. There actually are English language public universities also, but the majority has the obligation to learn French in Quebec, which I think is a reasonable requirement, even though English is the official language for all of Canada. In the context of a province or region where the majority are French-speaking, it makes sense for the majority to also learn the minority language in that situation. And I think that's the right balance. And I would say that's a non-discriminatory approach also. Thank you for that example. And Monsieur, and Madame. Monsieur.
My question could be summarized into the sentence that English teaching solves all the problem, or say popular language teaching solves all the problem. I think we all know such cases that some government of non-English speaking countries greenlights to the schools with English of instruction language, so-called international schools, regardless of a complex legal problem on other cases. Here, we also find many cases in Europe, and I'm not talking about the preservation of national language. I've seen in some cases in some French-speaking countries. My observation in some cases in the world is like students of minority succeeded in learning English in such situation or other popular language, but failed to integrate into the main society of the language.
I would disagree probably with you in a number of areas. There are studies that show, and I don't have it here, but there are studies that show that only using English when it's not the language of the children has negative results.
Yes, negative results.
So English, if I may, English only in a number of countries, and this is Africa, I would add, using English only is not a solution. It's not the best approach because there are research that clearly shows that using English has very negative effects on the school results of children. I'm sorry I don't have this here, but I do have the information. So maybe I misunderstood.
Yeah. For example, in some practice of some cities in Europe, the government advised the parents of migrants to send their children to international school where the language of instruction is English.
Yeah. No, and I don't think that's a solution. In the sense that if you are living in a European country and you only learn English and not the local language, I think that's actually also not appropriate. It's not balanced. So I'm reacting because if you allow me, if you are suggesting that English is a world language, it's no doubt, it's important international language. But English only or English mainly in education might actually create situations where you have individuals who never learn the national language. That's okay. Well, let's just stay there and say that that's actually probably not a good result either, because it actually creates an elite. And there are countries where you have an elite that actually would speak English, and then you have the rest of the population that does not. And that actually is quite negative. It creates a number of problems in some countries. The next person is, no, Madame is first, and then Judah. Yes.
Thanks. So my question is about the language situation in my country, in Georgia. There are two unwritten languages which are used only at home. in 2 regions of my country, and children from kindergarten age are already educated in Georgian. So these 2 languages are not used in any kind of educational state. These languages are already kind of endangered. I would say they are not in the catalog of endangered languages yet, but still the tendency is that the fluent speakers of these languages decrease.